All right, welcome everybody to Attorney Action Club Online. It is great to have you. I'm going to be moderating in the background. Al's going to introduce our speakers. Those of you that have never been to Attorney Action Club, Al, do you mind telling us why you got this started in the first place?
Yeah, thank you, Leo. We're basically a community of attorneys and those who support attorneys that have traditionally met the third Thursday of every month in person. Now we're in a bit of a hiatus, so we've moved to a Thursday afternoon Zoom call. We've been doing these around 3 o'clock, work in the morning, and then do some CLE in the afternoon once a week. So that's the idea. And there have been a lot of legal issues that have certainly arisen over the last month. And so each Thursday we're showcasing a topic. Last week was landlord-tenant. This week is insurance. Next week is going to be litigation dates and statute of limitations issues and law in motion issues that have come up because of all these orders. But today we have business interruption insurance or business insurance claims generally. And our two speakers are Peter Roldan. Many of you know Peter. He's spoken now twice at the Attorney Action Club. He's spoken on the duty to defend, meaning when one of our clients or somebody you're helping out gets sued and the insurance company needs a little help understanding what they need to do to protect your client. Peter is really good at those cases and helping out. He's also an expert in the blockchain. He's spoken on Bitcoin as well at the Attorney Action Club. Nicole Hess is our other speaker, and Nicole is also an expert in insurance law in all aspects of it. And I've gotten to know Nicole in my personal injury practice where the defendants that I've sued have been helped by Nicole if there's a reservation of rights issue or a question about whether or not they're going to indemnify the defendant for the loss. Nicole does a very good job of, again, helping the insurance companies understand what they need to do to protect their insured and her client. So I'll turn it over to Peter to start the show.
Great, thanks, Al. Let me go ahead and get these slides up. Hopefully this works out. And yeah, this is actually a great time to do this, Al. 3 o'clock. It's usually around the time of day I'm tempted to lay down and take a nap since I've been working at home for most of the day. But instead, here I am with presenting. So it's a great opportunity, and it's also a great chance to work with Nicole Hess, who I understand is another experienced coverage attorney. Today we're going to be spending some time just looking at insurance coverage for claims arising out of the COVID-19 civil authority shutdowns. There's a lot of businesses out there who have either are going through slowdowns or complete shutdowns of their operations and are losing a lot of income. And the calls have already been coming into my office from these businesses to find out whether their commercial property policies, their insurance policies will respond and help them recover something for these losses. It's especially of concern for a lot of potential clients and clients of mine in the hospitality industries, including hotels, restaurants, and bars, because they're obviously losing a lot of money right now. I want to start by just looking at some of the types of policies that might be responding to these claims arising out of the coronavirus shutdowns. Primarily, you're going to be looking at the first two policies on the slide: commercial property, which covers basically the property, first-party coverage for your property. And I also mentioned business owners package policies, because a lot of times, especially for smaller businesses, the property coverage will be in one policy. So you might actually be, if you have a client who's looking for their policy and wondering which one it is that they need, it sometimes will be known as a business owner's package policy. We'll also touch a little bit on event cancellation policies, which are specifically for events as opposed to ongoing businesses. And we won't really get into this too much, but I did want to touch on availability of coverage for liability claims under your CGL policies, to the extent you might have, say, a customer or basically somebody who's claiming maybe that they suffered as a result of exposure to the virus while at your business. There's a chance that your CGL policy might respond. But for the purposes of this presentation, we'll really be focusing on first party coverage. And when we're looking at first party coverage arising out of the virus exposure and the closure of these businesses, we're really looking at 4 types of potential claims. The first is property damage. That's really the most basic coverage under a commercial property policy. It covers the cost of repairing or replacing damaged property. And it's, as we'll get into, it's also important because the existence of covered property damage is required in order to trigger the other 3 coverages, which I think are going to be of most interest to policyholders dealing with coronavirus claims. And those coverages are your business interruption, or also known as business income coverage, your civil authority coverage, and what's known as contingent business interruption. Again, these are the types of coverages that will respond in situations where an insured's business has slowed down or shut down as a result of some kind of property damage or an order by the government to close their businesses. Now, property damage, again, it's an important issue here because even though a lot of the losses that businesses are suffering now are a result of their businesses not being able to operate, in order for there to be a covered claim, there needs to be a covered property damage event that triggers coverage. And the law's pretty clear. In some ways it's clear, in other ways it's not so clear as to what constitutes property damage for the purposes of a first party insurance policy. Generally speaking, property damage refers to direct physical loss or damage to covered property. That's basically going to include your insured location and the property located at the insured location. Things like your buildings, your inventory, fixtures, things like that. And another issue is going to be whether your policy is what's known as an open peril policy or all risks versus a named peril policy. And that's going to be important in this situation because an open peril policy, the way that works is it provides coverage for any damage to property by or any physical loss or damage to property unless it's caused by an excluded cause of loss. Named perils, on the other hand, only covers damage caused by a specifically named peril, like fire, water damage. Those are the two main ones, but there's a specific list of named perils. And the reason that's important is because most named peril policies are not going to include viruses or contamination as a named peril. You will see that in some specialty policies, especially some hotels will have these named peril policies that do include virus or contamination, but for the most part, that's not a common named peril. And Nicole, if I'm wrong about that, please feel free to jump in. But in my experience is you're not going to see a lot of named peril policies that include virus. Whereas under an open peril policy, if you can't have contamination that constitutes property damage, that will be a covered cause of loss unless it's excluded. And we'll get into that a little later. And again, the reason that's important is because without this covered property damage, there's not going to be a trigger of coverage for your business interruption or civil authority coverages. Now, getting into business income, this is the first place a lot of policyholders will look in this situation where the businesses have slowed down or shut down as a result of the COVID-19 shelter-in-place orders. And what business income coverage does, it really provides, it reimburses businesses for lost business income or profits due to their closure of a business as a result of property damage to the insured location. So there's two requirements here. The first, which we've talked about, is you need to have covered property damage to insured property. The second one is that you actually have to have a suspension of operations. And this can get tricky as well, because some policies I've seen define suspension as both a complete shutdown of your operations or a slowdown of operations, meaning that you have severely reduced a business as a result of the stoppage. And that's important for businesses such as hotels or restaurants, because a lot of them, even though they're suffering and they've got significant slowdowns in their business, they're still operating. Just because your restaurant's dining room is closed and you've shifted to takeout, for a lot of restaurants, that could mean a huge reduction in business, but it wouldn't be considered a complete shutdown if that's what your policy requires. Whereas other businesses, for example, a bar, those have actually been shut down, and so they would easily fall within the definition of suspension of operations, even under the more strict definition of complete shutdown. So again, that's something to keep in mind when talking to your clients who have businesses that have lost operations time as a result of the COVID-19 shutdowns. And finally, there's also going to be a time limit, and that time limit is based on what's known as the period of restoration. It's essentially the time it takes for your business to repair the damage to the property and then to come back to operations. And if not, there's usually a 30 or 60 day time limit, if whichever one is shorter. So it's not, your coverage isn't going to be essentially open-ended. There are limits as to the time, and there's also usually a 72-hour waiting period. So if your business shuts down, you have to actually wait 3 days before the losses from your business are going to start to be covered. In this situation, it's probably not going to be a huge issue because the shutdowns are going to continue for more than 72 hours, but it does come up a lot of times in situations such as fires where access to businesses or businesses are able to reopen within a few days. So what's covered under a business interruption? I touched on this earlier, but what you're looking at is it covers your net income as opposed to gross revenue. So your profits before income taxes. It can also include your continuing operating expenses, payroll being a big one. And I did touch on the 72-hour waiting period that's included in most policies. And we talked about the concept of period of restoration, which essentially means it only covers the time you've actually shut down. And this actually, again, gets a little tricky because once, as far as strictly speaking under the policy, once your operations go back online, that's when the period of restoration ends. It doesn't matter actually if you have a policy that only covers a shutdown, or rather if you have the repairs to the property that are completed and you're able to start operations even on a limited basis. As far as the policy is concerned, your period of restoration is ended because the repairs to the covered property have been completed, and therefore what you'll need in that case is to look to what's known as extended business income, which provides further coverage to your business after repairs are completed, but during the period where your business is kind of bringing itself back up to its pre-loss levels. And I think Nicole might be able to touch on this as well. There's a lot of fights over, how and when extended business income coverage is actually triggered. Now, contingent business interruption is is another key one, especially for, again, for businesses that are in manufacturing. It's also important for, I think, businesses that rely on, for example, tourism, hotels. Basically, contingent business interruption covers a business for lost income caused by damage not to the business itself, but to a business that the policyholder relies on. For example, if you're manufacturing, for example, if you have a manufacturer that relies on a certain supplier, and that supplier suffers damage to the property that makes it impossible for supplies that you need to do your manufacturing, that causes you to shut down, that will be covered under your contingent business interruption. I think in this case, it's important for a lot of the tourism and convention type businesses, because a lot of their policies will provide coverage for what's known as leader attractions. For example, we might have businesses down the road arguing that the fact that the Moscone centers had to close down and stop all convention activity, that caused losses to hotels, which especially the ones that are located near the convention center. If you have a hotel or restaurant that's near an amusement park, they might have policies that consider the amusement park a leader business, and if that amusement park shuts down, there could be coverage triggered under that policy. The lesson is, always look at what your client's policy has and see what businesses might be considered triggers for contingent or leader business losses. And we also have civil authority coverage. And I think in our situation, this is the most likely coverage to be triggered by the events that are happening here in San Francisco and throughout the country. Civil authority coverage provides an insured with coverage for income loss caused by the action of a civil authority that prohibits access to the business. And in this case, I think, again, especially if you're operating a business that's been deemed non-essential and has been ordered to close, I think you have the first part of that down. You have an action of a civil authority that prohibits access to your business. You can't go to a bar right now, for example. The key question is, and it's already being litigated, I think it's probably a little too early for this, because I don't think there's even been coverage denials yet, but the key issue is whether this order of civil authority is a result of covered property damage. Because just like your business income coverage, in order for civil authority coverage to trigger, you need to have property damage caused by a covered cause of loss to property, which triggers the order of civil authority action. And the big question is going to be whether the virus, the presence of the COVID-19 novel coronavirus, could be considered property damage. I don't really have I don't think this is the time to get into the case law, and because there is a lot of sort of analogous case law as to whether things like contamination or the presence of a virus could be considered property damage. But in this case, I think as policyholder attorneys, the argument is going to be that the presence of the virus itself, as opposed to, the policyholder side will say the presence of a virus on property should be considered property damage because it makes that property unusable. For example, if you were to have some kind of pollution, or that's not a bad example, but the presence of a harmful substance has been found to be considered property damage. As somebody who's also done this on the insurer side, I think the argument I would make is that it's not actually the presence of the virus itself that's triggered the order of civil authority. It's actually the reason that the order was enacted was to prevent people from congregating and to prevent contagion, which is not the presence of the virus itself, but rather the presence of people in proximity to each other. I mean, these are all questions that I think are going to be litigated for a few years, but I think for now, just the thing to keep in mind is, was your client's business actually closed by an order of civil authority? And I think for certain businesses that are being deemed non-essential businesses, then I think the answer to that question is pretty clear. But if we're talking about hotels or restaurants that continue to operate, but at a much lower capacity, I think there's going to be a question as to whether the order of civil authority, namely in this case, taking San Francisco, for example, whether the shelter-in-place order prohibits access to restaurants, that's going to be an open question. I don't think that the carriers, the insurance carriers, are going to concede that that's the case when people are still doing takeout business. And finally, get to exclusions. As I mentioned before, there's certain exclusions that can apply to open peril policies, and one that I've already seen in a couple clients of mine who have come to me with this question is the virus biological agent exclusion. And the ones I've seen have been broad. Some exclusions will only apply to certain types of coverage, but in the policies I've been seeing, there's been a pretty broad virus exclusion. And this is an ISO form, an insurance services office form, which essentially means it's going to be pretty widespread, and it's also the kind of policy form that gets filed with state insurance offices and is approved. So unfortunately, it's going to be one that is going to be in a lot of policies. And so policyholders are trying to figure out if there's ways around that, but I think it's going to be a tough one to get around if this does actually exist in your client's policy. There was some interesting, I think, talk in New Jersey about legislation to try to get insurance carriers to step up and cover coronavirus business interruption losses. Even as a policyholder attorney, I'm a little skeptical of whether those efforts are really going to be successful. Essentially, I think whoever's putting, this is in New Jersey, essentially the governor of New Jersey and the legislature are asking insurance companies to rewrite their contracts with their insureds to basically provide coverage that was not necessarily something that they agreed on. So, even if that legislation were to pass, I think it would be tied up in litigation for a long time. And I think there's questions as to whether a government can actually force two private actors to rewrite their contracts. And finally get to making a claim. And I think this is actually where I'll be turning it over to Nicole, but basically just my comments are always make a claim if you think you have a claim. Provide timely notice to your insurer, keep good records of when your business was closed, and keep copies of any orders that apply to your business that required you to close, and keep good records of your lost income, any expenses that you're incurring as a result of any shelter-in-place orders. And with that, I'll go ahead and pass it on to Nicole.
Great, thanks, Peter, for the wonderful overview of these COVID claims for insurance. And I am just going to open it up to a little bit, you have a COVID claim, what do you do? As an attorney who represents companies or individuals, or as a business owner, you may not have made a claim before, and you may not have suffered, or your clients may not have suffered, the serious and significant losses that so many people, especially those in the restaurant and hospitality industry, are experiencing right now. So the first thing to do before you make a claim is to first realize you have a claim. It should be pretty obvious in this instance. Have you been forced to shut down? Has your client been forced to shut down? Has your revenue either gone down to nothing or been significantly reduced? And if so, with these minefields and traps out there with COVID coverage, I would highly recommend that if there is a large loss, that you contact and this is just not just an advertisement for folks like Peter and me But retaining a coverage attorney who has experience in handling, taking an insured through the claims process is highly recommended. What they will do is they will take a look at your policy, understand what type of coverage your policy provides, and be able to provide notice in a way that best frames the facts to maximize your coverage. This can also be done sometimes with very knowledgeable brokers and agents who are out there. But I would recommend if there's a large loss and due to the many uncertainties with obtaining coverage for COVID claims, that you or your client do to at least discuss initially making the claim with an attorney who handles claims on behalf of policyholders. Each policy, and if you look at some of the documents that were posted, there is a form for the business interruption policy, has a clause in there regarding the policyholder's duties in the event of a loss. Make sure you get a copy of your policy. Your agent or your broker is able to provide that for you. The first thing you want to do is make sure it's the right policy year. So the first couple pages in that policy is what's called the declarations page. It will list who the insured is, make sure it's you, make sure that it's in effect that at the time period that this loss has occurred. So just make sure your time periods are right, because policies can change from year to year and you want to make sure you're operating with the correct policy terms. And then you'll want to scroll down and figure out how the policy requires that you report claims. There's typically a notice section, or in this particular document, the clause is called duties in the event of a loss. The insurer wants you to report the claim as soon as possible. Some of these are inapplicable, such as notify the police if a law may have been broken. That's probably not going to be an issue here. Give us prompt notice of a direct physical loss or damage, including a description of the property involved. So even when you get to the second prompt in the notice of loss, sort of a little red flag goes up in terms of how do I characterize this as direct physical loss or damage? As Peter discussed earlier, is the presence of the virus in a business, is that direct physical loss or damage? I would say yes, because it's made the business, it's contaminated. You can take a bleach wipe and you can wipe it off and thereby remedy it. But then again, you have another question that if you can so easily fix the physical damage, is your period of restoration over? Have you been restored? When does the coverage start or end? There's lots of these unanswered questions. I agree with Peter that your civil authority coverage is probably your best bet for obtaining coverage, because of the presence of the virus in other spaces has caused property damage, and civil authorities have issued orders shutting down your own business for longer periods of time than it can take to wipe up that virus with Lysol and or bleach. These are they're novel coverage issues having to do with this novel virus, and I don't think we will see answers very soon. So I recommend retaining an experienced coverage attorney to help walk you or your client through large losses, simply because there's so many potential problems, and insurers tend to seize on anything from the insured, the policyholder, that supports their denial. Insurance companies are in the business of selling a promise. They don't sell a product, they don't sell a service, they sell a promise. And so they're held to a special standard. These contracts are interpreted differently than many other contracts. While many of the rules of contract interpretation applies, insurance companies are special. They've told you they'll take care of you if an unforeseen calamity happens. And they're also often issuing these contracts of adhesion, take it or leave it. The policyholder doesn't have a lot of negotiating power in terms of getting coverage. Insurance companies are in the business of taking risks. They have no right to make a profit. And they sell this security, peace of mind, and when something happens, they do need to deliver it. And in the claims process, the claims professional is supposed to be on the side of the policyholder. They are supposed to help the insured with the claim, and the insurance company, as part of the implied covenant of good faith and fair dealing, what the opposite of is bad faith, These insurance companies are supposed to look for coverage, act in good faith. They cannot unreasonably delay payment or deny payment. And if, for instance, I don't quite see how this would happen here, but if there is an undisputed amount the insurer owes and there's some other issues you're still arguing about, the insurance company has an obligation to pay that undisputed amount to the policyholder. They need to protect them and to act upon that promise that they made them, because this relationship between the insurer and the policyholder is inherently unbalanced. So at the end of the day, the insurance company is just supposed to be there, exactly like all those commercials we see for Geico and Allstate, farmers. We cover that. They're supposed to be there when something happens. And that's something to keep in mind when dealing with issues with insurance companies, but it's also important to not trust them too much. Make sure all of your communications with them are in writing. If you have a phone call with the insurance company where they tell you something that is helpful for you, or if it's problematic, follow up in writing with an email. I had a conversation with you on this date. This is what you said. You want to make sure you are creating a record of all of your interactions with the insurance company should something not go right, and then the claim needs to go into litigation. Insurance companies have an obligation to keep track of all of their claim decisions. They have the insurance regulations require they keep contemporaneous notes of phone calls, letters that are had, and they are kept in a claim file for the policy. You can request this in disputes and in litigation. In my experience, these claim files are thousands and thousands of pages, and while they're helpful, they're incredibly difficult to navigate. So it's helpful for you to have your own repository of communications with the insurer that you can have and understand what information you've provided to them and what is necessary. So I anticipate, as Peter does as well, that there will be a significant amount of litigation regarding coverage for the coronavirus in the future in both third-party and first-party claims, mostly first party, because so many businesses have sustained loss due to the requirement to close. But there will also be litigation regarding what I anticipate is negligence and nuisance claims based on businesses that perhaps did not close and exposed people to the coronavirus, and people may have gotten sick or died when perhaps these businesses should have closed. I don't know. These are all questions that we will see the answers to over the next few years. So those are the insurance company's obligations to policyholders. Moving sort of transitioning into what happens if an insurer cancels your policy. Make sure you have a broker who knows what they're doing and that you trust. There are a lot of insurance agents and brokers out there. An agent is the agent of the policyholder, and they have access to generally a number of markets and insurers. Actually, that's the complete opposite. A broker is an insurance professional who has access to numerous markets, and they're typically the agent of the policyholder. An agent, on the other hand, like a Farmers or a State Farm, is typically only having access to that one individual insurer in terms of writing policies, and also is typically the agent of the insurance company. In my experience, the brokers who are not the agents of the insurance companies often have a little bit better understanding of the different policies that are available. They're not locked into one coverage form and one insurer. I have a number of brokers who I think very highly of and have worked with, I'm sure Peter does as well, who we could recommend in finding someone who can help you or your clients find insurance policies that are the best options that we can get. Like I discussed earlier, these are contracts of adhesion, and very often I'll say, this is something I want, this type of coverage, and the market just doesn't have it out there at that point in time. And in that case, you get the best option you can get. So what to think about when getting a new policy or renewing a policy? Again, I'd recommend you work with an agent who is experienced. And if you're in a specialized industry, it can be a good idea to work with a brokerage that handles other clients in that industry as well. Sometimes there are special coverages out there that can provide additional or broader protection that not every agent may be aware of or have access to. Some particular issues to look at. Peter discussed in these business policies, there's often only coverage for a complete stop in a business's operations versus a slowdown. I would recommend that you would want broad coverage. It may have an increase in premium, but if you are a restaurant and you are allowed to provide takeout, you are not having a complete stop in your operations, and you may not have access to any insurance coverage for the losses that you've sustained. You may also want to look at the waiting periods to see if that is a period that can be adjusted. 72 hours is sometimes maybe fine, or it may be a problem. You'll also want to look at your deductibles. A higher deductible can result often in a lower premium, which makes sense for some individuals or businesses, especially if you're able to get broader coverage and you may just have a higher deductible in the beginning in case of a loss. A lot of these decisions are insurance decisions, but many of them are business decisions based on risk and what a business or individual is willing to pay for. You'll also want to make sure you look at exclusions, and if there's any particular risks that you or your clients are aware of or specifically want coverage for, it's a good idea in writing to ask your brokers to get that coverage or have them explain to you why it doesn't exist or cannot be procured. The virus and bacteria exclusion that Peter discussed earlier in his discussion, I think is going to be one of the largest challenges in getting coverage under these first-party policies. One avenue that I can think of, and trying to think of ways to get around that exclusion, is if a policy is renewed or you move your insurance to a different brokerage and the subsequent renewal with the new policy has a broader exclusion than the prior policy, that exclusion is not applicable unless that was brought to your attention. So you may have an instance where your renewal was narrower than the prior policy. Say you didn't have the virus exclusion, then you had it, you weren't told about it, or you weren't told about it in a way that you understood it was part of your policy. That may be an avenue for coverage. It's a tough argument, but it's an argument I've won in the past, not in this particular circumstance, but it's out there. And when dealing with tricky exclusions and you have someone who has a large loss, it's helpful to try and be creative. So that is pretty much just a quick overview of the ABCs of opening a claim, general issues with insurance companies, and what to keep in mind in if you've been canceled or if you need a new policy. With that, I think I'll open it up to questions unless Peter has anything he would like to add.
No, I think that was great, Nicole. I mean, I absolutely agree that it helps to follow up with your claim. I think the better record that a policyholder can make, the easier it is to make a subsequent bad faith claim if there is an unreasonable delay in coverage or an unreasonable denial. And I thought you also made some good points about shopping around, especially if you're in a specialty market, if you're in the surplus lines market, there's a little more. If you have a good broker, there's a little more room to try to negotiate terms of coverage and to try to make sure that you've got a program in place that's going to cover the risks that your businesses face.
Oh, looks like a question. You see that, Leo?
Yes, the question is any idea how solvent the carriers are? The answer is always it depends. I mean, you can all the carriers are rated, and some carriers are rated higher than others. The only place so far where I've seen this is going to be an issue is I briefly mentioned the proposed legislation in New Jersey that would, that is essentially trying to force insurance companies to cover losses for the COVID-19 shutdowns. And if somehow that legislation were to pass, if I were a policyholder, I'd want to get in line right away, because I don't think a lot of the carriers would be able to survive that, just because I don't think that was, they underwrote those types of losses. So that's just something to keep in mind when looking at these legislations that might expand coverage. At the end of the day, you still need an insurance company that's going to be there to pay the loss. And I know from experience, having represented insurance companies that went under, it's a lot harder to get your money from an insurance company that's in the process of having its claims run down, as opposed to an insurance company that's still operating.
I absolutely agree with what Peter said. It's, you know, definitely file your claims early, even if it's not a state that's going to issue something from its legislature saying you need to cover it.
Well, thank you, Peter. Thank you, Nicole. Looks like we have another question here. You want to go ahead and handle that one, Peter?
I think, if somebody's willing to take on your case, or you're willing to pay somebody to bring a debt relief action, I think, as a coverage attorney, for me, I'd be interested in doing that, just because it gives me personally an opportunity to try to make some novel arguments. But from the client's perspective, I'm not actually, it probably won't get you paid any faster. If anything, it might actually slow down the process to the extent that you might have a claim that could otherwise be covered. I don't think there's right now, maybe Nicole has different thoughts, but I think a lot of the suits that we've seen filed, I think Al's pulled one from the French Laundry, and I believe the first case was in New Orleans seeking debt relief on this question. I think they're probably a little premature. I think the main reason they're out there is just to get it out and get some publicity. So I don't think there's any real need to do that now, as opposed to I think the important thing is to make sure you get your claims in order and start recording your losses.
I completely agree with Peter. In my practice, and I don't like to say always, because there's always exceptions, I generally don't file declaratory relief actions, because one, you're by doing this, you're saying to the court, I don't know if there's coverage, please let me know. I like to come from the position of, I believe there's coverage and the insurance company is wrong in denying coverage. And I realize you could cast your debt relief actions as, I believe there's coverage, please say so. But it seems to have a stronger approach when you are coming from, you breached the contract, and sure, you acted in bad faith. Also, in terms of just the practical impacts of it, with a debt relief action, the insurer is going to contend you don't get a jury. They're going to say it's just an equitable claim. I want a jury, especially with an issue like this, that everyone who's here knows someone who has COVID, whose business was impacted by COVID. You want a jury full of people who are impacted by this, who, even if the question's a little bit tenuous of whether or not there's coverage, maybe, swayed onto your side just because of their own personal experience with this.
Mm-hmm.
There's a
we have another
about...
question here, Peter or Nicole. Are you aware of any shelter-in-place orders that are specifically worded to trigger civil authority coverage? Jeremy Pollock writes that. He seems to recall that Napa may have done something like that.
I do think Napa did. I haven't read the Napa order though, but in the complaint filed on behalf of the French Laundry, I think they did make that allegation. I think in New Jersey that might be the case. I think those are helpful, but they wouldn't be determinative, I don't think, of whether the presence of the virus actually would constitute covered property loss. But it certainly couldn't hurt.
Mm-hmm.
But I can't, I know San Francisco does not say that.
Mhm. Well, thank you both for doing this on short notice. I know I learned a lot, and if anybody wants to get a hold of Peter or Nicole, reach out to me if you don't have their contact info, and I will connect you if you can't get a hold of them via their website. I do agree with Nicole. How the claim is characterized and presented can be very important. So if you have clients in this position, reach out to an expert. And certainly my heart goes out to so many of the restaurant owners and people in the hospitality industry who need our help and our expertise in the legal profession, both in this area and in so many areas of the law. I think it's a great time for us as lawyers to just stand up and do what we can to help people who are really, really hurting right now. So thank you too, appreciate it. Leo, you want to end the meeting or end it up here for us?
Yeah, well, thank you so much for attending, everybody. There will be MCLE credit again for this, so we'll send a message out to the group. If you have any questions at all for Peter, you want to be connected to them, please don't hesitate to reach out to Al or I or through the website. We'll make sure that you get connected. Thanks for coming, and we'll be back again next week.